We're going to talk about the top 5 mistakes that employers make. The first thing on the agenda is, who cares what you post? Well, there are groups out there that do care. We're going to talk about mistake number 1, which is not posting local posters. Number 2 is not recognizing that posting laws apply to remote workers, people you have working from home or away from your office. Mistake number 3 is assuming that a foreign language poster is optional. 4 is displaying only one set of posters in a large business. And number 5 is assuming that posting requirements are the same for all businesses. Then we're going to talk about the risks of non-compliance. What happens if you are found to be non-compliant with these posting requirements, and how to remain compliant going forward if you're not right now. The purpose of posters is to inform employees of their legal rights and responsibilities. And that's both rights and responsibilities, because they have things that they have to do in order to have the rights that are posted on your wall. And that's important to know in case of litigation. Who cares what you post? There are federal agencies that require and monitor these postings. The first is the EEOC, Equal Employment Opportunity Commission. Then there's OSHA for safety. The Department of Labor has several posters in several areas. The FMLA law, if you have more than 50 employees. The Fair Labor Standards Act, which is our wage and hour division of the Department of Labor. The Employee Polygraph Protection Act is another poster that's required. And the Uniformed Services Employment and Reemployment Rights Act, which is USERRA, as many of you may know. Plus, there are state and local governments that care what you post. Each state is different and can require up to 15 additional posters depending on the type of employer you are, how many employees you have, etc., etc. Government contractors also have additional posting requirements. Mistake number 1, not posting those local posters. There are cities that have laws that are more generous even than the federal and the state laws. A lot of California, there's some in Pennsylvania. New York City has some laws that are more general than the state laws there. So it's important to know which posters you're supposed to have for which state. Some of it may deal with minimum wage or paid leave laws, which are rampant right now, and non-discrimination guidelines. Back up to the minimum wage. The minimum wage, federal wage, is $7.25, but most states have a minimum wage that is much higher than that, and that's why when the state wage, minimum wage, is higher, you have to pay that, and so you have to have a poster for it. So non-discrimination guidelines. Some areas might have additional protected classes. That is sexual orientation. If you're in California, it's all across the board, and other states are also adding different protected classes. So it is a mistake not to post those local posters. Mistake number 2 is not recognizing that posting laws apply to your remote workers also. You must notify all employees, and the format is not specified under the laws, state or federal. So it can be electronic or it can be paper. Just use your best judgment when you're doing this. If the person is in your office several times a month, their access to your posters should be sufficient. But if not, if they're never in your office or they're in your office twice a year, then you're going to have to figure out how to make sure that they have a notice of these posters. Notices should be available in this case via email or internet or intranet, whichever works best for your company. Mistake number 3 is assuming that a foreign language poster is optional. I guess assuming anything is a bad idea nowadays. In 21 states and the District of Columbia, posters in both English and Spanish are required regardless of your demographics. If your workforce contains a significant number of Spanish-speaking employees, posters have to be in English and Spanish regardless of the state rules. Here's a list of all the states that require both English and Spanish posters. And this webinar will be available. It's being recorded. It will be available later if you need this, or if you want a PDF of it, just send me an email afterwards and I'll shoot the presentation to you in PDF format. So there are 21 states, and it looks like it's the bottom half of the United States except for the really, really cold ones up north. So for the most part, and Puerto Rico is also included in that. So mistake number 4 is displaying only one set of posters in a large facility. Labor law posters have to be displayed in a very prominent or conspicuous place throughout the business, not just in one place. If you have warehouses all over the place, they have to be in each facility. They have to be accessible to all employees. And so that implies that those areas are frequently visited by your employees. Target highly visible areas that get the most traffic, like the employee entrance where they come in the mornings, the break room where they eat lunch, or the time clock area if it's separate from the employee entrance. That's where you're going to be able to prove that the majority of people saw that poster. In addition, there are 4 federal posters that have to be displayed in areas where applicants can view, and the focus here is on the applicants. They may not go to your employee break room or where the time clock is. So the posters that are required in an applicant area are the EEOC poster, the USERRA poster. This is the one on the Polygraph Protection Act, and FMLA for companies with more than 50 employees. So it may be your lobby. It may be an area where you have applicants enter the building. So that these 4 posters have to be in view of those individuals. If you're doing postings online, you have to have a link to your current federal posters. So there needs to be some sort of a link in your job app or your job posting that has these links. Mistake number 5 is assuming that posting requirements are the same for all businesses. And I would love to be able to look you guys in the face right now and ask you what industries you're from, but I'm assuming it's across the board. Certain businesses have additional industry-specific posting requirements. One of those is the public sector or government employers. They have to have a poster about E-Verify, the Right to Know poster, the Whistleblower Protection poster, notices about electronic monitoring. And then if you're a healthcare facility, a doctor's office, a hospital, a dentist office, you have up to 15 additional notices or posters that you have to make sure that employees have access to. They deal with biohazards, radiation areas, HIPAA, and a ton more. And I'm sure that if you're in a healthcare facility, you have very strict regulations and have a long list of things that you know you're supposed to be either handing out or posting because of the regulations that apply to healthcare facilities, very strict regulations. And it does depend on your state or your type of facility. So a hospital may have more notices required than a doctor's office or dentist office. Restaurants, if you run a restaurant business, the postings depend on the state. Choking assistance information has to be posted on the wall. There has to be a poster that talks to employees about being a tipped employee, how to do CPR, posting for that, and information about serving alcohol to minors. Those are just a few that would be required. So you see, across all of this, it's not just a federal requirement. Some of this is just required by OSHA or Wage and Hour and different organizations out there that are either protecting the employees or protecting the people who come into the facility. The list goes on, and I've just taken a few of them here with hospitals and restaurant and government workers. Government contractors will spend a little bit more time on that. I'm not sure if there is anyone on the line that is one, but the postings will depend on the type of contracts you have and with what agencies you deal with. The most common are listed here. And look at, there's like all these different notices. Minimum wage, obviously there's a different minimum wage for government contractors in some areas. Pay transparency statement, the DoD fraud hotline, the Davis-Bacon Act. So this doesn't mean that you're a government employer. This is a government contractor, which means that you have a contract with the federal government, probably over $50,000 a year, because that's when you start having to report EEO-1 information. But this is something that if you do have a government contract, you have to have all your other posters and these. Okay, so what are the risks of noncompliance? The fines are really steep. Multiple locations, if you have several different locations, let's just say you're a restaurant facility and you have multiple locations, or you're a manufacturing company with different warehouses. Those multiple locations could have different violations at each one. Federal level violations can be $35,000 or more per location. So that's pretty steep. And I would hate to be the HR person that got a notice of this and had to present that to my boss, because I think they probably expect that you know what to post and when, and that's embarrassing. And also job threatening, probably too. State and local level violations typically range between $100 and $1,000 per violation. So each posting carries its own fines. And how does this happen? How do you get discovered about not having the right posters? Well, it's usually because there's an agency on your premises for another reason, and they're going to check out your posters while they're there. OSHA inspectors do it, Department of Labor inspectors do it, and the EEOC will also do it. If they happen to be there for something else, they will look at your posters, and sometimes it's a cross-agency sharing effort. They will, if they don't see the posters for your EEOC, the Department of Labor may report you to the EEOC. So they generally do share information. And it's not just about the fines. The real danger and the real expense is in a lawsuit. Someone sues you for discrimination or violating one of their rights on those posters. However, there is a statute of limitations that's indicated on the posters. And this is a big advantage for employers, because if you have the posters up, that poster allows for dismissal of the claim if they don't file it in a timely manner. Let's just say they wait 3 years or 2 years or outside of the statute of limitations and file, and you can prove you had posters up, that said you have X number of years or days or months to file this, that's going to shut down their lawsuit and the charge. But if no poster exists, the statute of limitations may not apply in a court case. They'll say you did not notify them of their rights, therefore you're responsible for that. Not notifying employees of their rights and responsibilities can be seen as dealing in bad faith. So it's just not paper on the wall. It is a responsibility to educate applicants and employees about their rights and responsibilities. And no, none of them ever read the posters. We know that. If you've ever lived in HR, you know that they don't read anything you send them, much less the poster on the wall. So, but it is your responsibility as an employer to be able to prove that you had these posters up and in a prominent position. If you don't have them and you can't prove that you had a poster, the damages in a lawsuit can be increased because it looks as though you don't care. How to remain compliant. There aren't enough hours in the day. First of all, there is no one-stop shop for free government posters on a federal, state, and local level. What you can do, there are two ways. You can research every labor law posting requirement, and then you can call that agency and request, or go online and request a current poster. If you're in one small town, this might be feasible for you because that's not a problem. But if you need to put up 25 posters because of the type of place your workplace you have, and you're in multi-state locations, then that's going to be a hardship for you. And then after you get those current posters, in this scenario, you post them in areas frequented by employees, and I forgot here, the applicants for some of those posters. Then review your postings periodically for updates because things do change. Generally, things change January 1 and July 1 of each year. Or you could subscribe to a labor law posting service and post those posters in areas frequented by employers. If you are a Payentry client right now, you have access to a free labor law posting service through Poster Elite. If you need more information on that, if you don't know about that, reach out to your service rep and they will give you more information on who to call and how to get those posters. But it is a free service for Payentry clients. Poster services will automatically provide updates when they're legally required. And that's crucial because you may not be paying attention to a new law in a municipality that you have businesses in, but they will know that because it goes all the way down to the local level. And that's the end of our webinar on labor law posters today. I feel like I should apologize because these webinars are not long, but I try to get them action-packed and full of information. And if you want a copy of the PowerPoint, please send me an email. Or if you have a question that I haven't answered throughout this webinar. Right now, the chat is open for you if you want to type in a question, or if you'd like to just shoot me an email afterwards. Either way is fine with me. I've enjoyed talking to you today, and hopefully in the future we'll meet some of you. If you ever get to Huntersville, North Carolina, I hope you have a great afternoon, and please let me know if you have any questions. It is my job to answer your questions, and I'm happy to do so on any HR topic. Thank you.